When can school officials search students' belongings? What reasonable expectations of privacy do students have in schools? How much drug paraphernalia do you carry around in your purse, Jamie?
On today's episode, we'll go back to the early 1980s to discuss the landmark Supreme Court case that would redefine the boundaries of privacy and authority in schools. This is New Jersey versus TLO, a case involving searching the possessions of a 14-year-old freshman, and a case that continues to resonate and influence how we balance students' rights and school authority.
Is this the oldest case we've talked about, Jamie?
I think it is.
It's close, if not.
Yeah, I think it might be the oldest case we've talked about. Yep.
This case is older than me.
It's not older than me.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Chris, what is this week's bell ringer?
Yeah, so going back to a topic that we've talked about a lot with these educational gag orders that have been going along in a variety of states. You know, we've been talking about how they're finally getting litigated and there's been some judicial opinions and things like that. Well, a lawsuit that was challenging Florida's Parental Rights in Education Act, or colloquially called the Don't Say Gay bill, they just settled that lawsuit. So the state and the plaintiffs came to a settlement agreement to basically resolve that lawsuit.
Really?
Yeah.
So what were they claiming?
The claim was that the ban on, how it approached teaching or talking about issues related to gender or sexual orientation violated, the First Amendment, equal protection, all of the things that we've kind of talked about. And the interesting thing about the settlement is both sides are claiming it as a win, which is, maybe that means it's a good settlement, right?
Okay.
The old joke is, a settlement is good if it disappoints both sides, right? So the settlement essentially just kind of...
You lawyers are so funny.
We got jokes. But the settlement basically just requires the state to remove ambiguity from what the law means. And so the settlement, which they entered into in kind of the beginning of March, essentially outlines more clearly what the scope of the law is. So the law is still in effect after the settlement, but the meaning of the law is much more clear or curtailed, perhaps. So it still prohibits teaching gender identity and sexual orientation in classroom instructions, but it requires the state to kind of say what that is and what that means and where those lines are.
Okay.
There's a lot of examples that the settlement gives about things that the law does not apply to. And this goes back to, Jamie, something you and I have talked about where these laws are written in an incredibly kind of vague way.
Right.
And they don't explicitly say kind of what they mean or how they're going to be applied. And so that ambiguity is a big challenge with these laws. And so the settlement, it seems like part of the goal of the settlement was to remove a lot of that ambiguity.
Right.
So just to give you kind of some examples of how the law kind of removes some of the ambiguity to kind of hopefully give teachers a little bit more confidence as they navigate this area. The settlement says that, here's some examples of things that are allowed under the law. So teachers can respond to students who choose to discuss their own families or identities and can grade essays that include LGBTQ topics. Teachers can make reference to LGBTQ people in literature or history. Student-to-student speech and classroom debates can touch on LGBTQ issues. Schools can explicitly protect LGBTQ students in anti-bullying efforts, and teachers can have safe space stickers in their classrooms. And students of the same gender can dance together at school dances and wear clothing considered inconsistent with their gender assigned at birth. So
there's very specific and things that teachers and schools have really been wrestling with these laws. Like those are really sort of common practical pieces of guidance, right?
Right. That help kind of delineate what constitutes classroom instruction and what doesn't. Right. Yeah. And so I think that's what is really happening here, because we saw, and the recent research kind of backs this up, that teachers were being very cautious about these laws and they're engaging in a lot of self-censorship.
Yeah.
Even though we don't know necessarily how these laws are going to be enforced and what they mean. And so having that clarity helps out. Another piece of this settlement that I think is really, really interesting is that the settlement also clarifies that the restrictions on classroom instruction apply regardless of viewpoint. And that's really interesting because the laws themselves say you can't teach gender identity or sexual orientation.
Right.
They don't say anything about heterosexuality or homosexuality or, cisgender, transgender status, anything. So basically what the settlement says is hey, if you want to apply this against LGBTQ folks, that would be viewpoint discrimination. So you've got to also apply it to heterosexual couples, cisgender individuals as well.
Yeah, exactly. So if you're going to refuse to discuss marriage between two people of the same sex, then you also have to not talk about marriage between two people of opposite sex.
Exactly.
This is fascinating.
It is.
It's just a very interesting time right now as we start to see how these laws that are popping up everywhere over the last few years, how they're starting to play out in the courts. And we knew, I remember talking to my students about it a few years ago when these laws were just starting to take hold. I remember saying the next 5 or 6 years are going to be really interesting to see how this stuff plays out. Right.
And as we start to finally adjudicate the kind of lawfulness of these, or the legal challenges kind of play out, it's going to be really interesting to see not only what the law is and what it develops to be, but also what the practical impact and long-term effects of this are going to be. Because, we can't unring that bell, so to speak, right? So even though this settlement is in place, all of these folks have been living under this ambiguous law for years.
Right.
And have done, have taken actions because of what the law has said. And so, we've got this settlement now. It still leaves the law in place, but it clarifies it. But that still means that there were years of teachers having to navigate this without the full understanding of what the law meant.
Well, the law itself didn't know what it meant. Or the lawmakers themselves did not know exactly what.
And the state, never really told us. So,
Wow. Interesting stuff, man. Okay. Why don't we dive into today's case, which is, this is really cool because we haven't done one of these foundational education cases yet. So, anybody who's familiar with, at least the least bit familiar with education law, this is one of those first cases, that's covered in education law courses and things like that, because it's one of those foundational Supreme Court cases that deals with student searches. Okay, you ready for the facts?
I'm ready to make a bunch of Motley Crue jokes.
You weren't even around when...
I do know the song Smoking in the Boys' Room.
Oh.
And so Smoking in the Girls' Room.
All right, so this is March 7th, 1980. So we are in a high school in New Jersey. Is it Piscataway High School?
Sure.
Do we know if that's pronounced right?
I don't know, actually.
I'm going to go with Piscataway High School. I could be butchering that, but that's what it is for right now.
That would be the first time we've ever mispronounced something on this show, so be very careful.
All right, so on March 7th, we have a teacher at Piscataway High School in New Jersey.
I appreciate the confidence. You just went for it. There it is.
I know. I'm
there.
Putting a stake in the ground and we're just, okay. So this teacher discovered two girls smoking in a bathroom. One of the girls, because they were a minor at the time, and we use initials in these court cases when we're dealing with a minor. So the initials of this particular student are TLO. And TLO was a 14-year-old freshman at the time. So in 1980, TLO is 14 years old. And what we do know is that smoking was against school rules. Now, for those of you young listeners out there, probably very difficult to fathom that this was an actual thing back in the 80s. But I remember being in elementary school and walking by. Now, none of the kids were smoking in elementary school, but I remember I was in elementary school in the 1980s, and I remember walking by the staff lounge. And it was just a haze of smoke. Like I have that memory from my childhood. And I remember seeing ashtrays on teachers' desks. Now, I don't recall any teacher ever smoking while we were in the classroom. But like, looking back on it now, I'm like, well, as soon as we left for the day, teachers are sitting at their desks smoking cigarettes.
Jeez.
Yeah, times were different back then.
Yeah, very different. Now it's just students and vape pens, right?
Exactly. Which, for the purposes of this case, it's an interesting sort of distinction between cigarettes and vape pens, and we can talk about that later. But, the short version there is like, it's not hard to smell somebody smoking a cigarette and know exactly what's going on. That's much more difficult with vape pens, right? So anyway, all right. So here's what we've got. We've got the teacher that discovers these two girls smoking in the bathroom. One of them, TLO, she's a 14-year-old freshman. Now, the teacher takes both of the girls to the principal's office. And there they meet with Assistant Vice Principal Choplik or Choplik. I don't know. We're going with Choplik today. So it's Piscataway High School and it's Assistant Vice Principal Choplik.
That's how I read it in my head.
Okay,
So
excellent.
let's do it.
And he questioned the girls. So TLO's friend admitted to smoking in the bathroom, but TLO denied smoking in the bathroom. Okay.
TLO went further than that too.
Yeah,
didn't she said
she did. She's like, I don't even smoke. I don't know if that's what she said or if that's how she said it, but she claimed to not even be a smoker. Okay.
It's the Shaggy defense.
Yeah.
Wasn't me.
So apparently Choplik asked TLO, this is a little problematic, I think, but Choplik asked TLO to go back to his private office and he shut the door while he questioned her. I did not get the sense from reading any of this that anybody else was in there when he did this. So yeah, taking a female student back to your private office and closing the door alone is generally not good practice.
Right.
Okay. So in there, Choplik insisted on searching TLO's purse. So when he did that, here's what he found. He found a pack of cigarettes.
Right there on the top?
Right there.
Whoops.
Yeah. So he pulled out the cigarettes and he accused TLO of lying to him. And he thought that a deeper search of the purse could potentially yield some more stuff.
It wasn't just cigarettes that he saw when he first opened the purse.
Oh, right,
was
right.
It?
He also saw the rolling papers. Okay.
For tobacco, obviously.
Well,
because she's a 14-year-old girl who
rolls her own cigarettes.
Yeah.
But
right?
she had, now, I'm going to go out on a limb here and say she had a pack of cigarettes. That was the tobacco product. Rolling papers were likely there for a different purpose. So he thought that a deeper search of the purse could potentially yield some more evidence of something.
Because like you, the AP here is like rolling papers. I think that just screams marijuana to me.
Yeah, exactly. So Choplik searched further in the purse. And, I believe that he did say something to that effect, Chris, that like in his experience, rolling papers were a sign of marijuana use. So he kept going, and here's what he found. He found a small amount of marijuana.
Oh.
He also found a pipe. Now, like a pipe for smoking marijuana, which was probably different than one of those,
Sherlock Holmes
pipes.
Yeah. Though that's what I'm picturing now in TLO's purse, and
Isn't like
I
a
prefer
Sherlock.
that. Yeah.
Okay. All right. We can go with that. Also found a number of empty plastic baggies, an index card that did not contain vocab words from English class. It contained a list of names of students who owed TLO money.
Okay.
Also found
Just a polite student who's loaning her classmates money for soda or whatever.
and keeping meticulous track of that on an index card. And also 2 letters that implicated TLO in dealing pot, plus a substantial amount of money in $1 bills. Now, that's what it says in the court records, a substantial amount of money in $1 bills. What we know is that dollar amount was about 40.
It was about $41.
$41. Now, you might be thinking, $41 is not a substantial amount of money, but keep in mind 2 things. One is $40 in 1980 is worth about $160 in today's terms. And $160 is probably
on a middle
little,
schooler.
Yeah, on a 14-year-old is probably on the high side. And actually, the middle schooler herself was probably on the high side. Sorry.
Low hanging fruit.
I know. Sorry. That was okay. No, but she wasn't a middle schooler. She was, this was high school, 9th grader. Okay. So here's what happened. Choplik notified TLO's mom and notified the police.
Right.
Because of the drugs. All right. Turned all of the evidence of the drugs over to the police.
Right. And this is like, so 1980, we as a nation are into the war on drugs at this point, right? Like as a social policy, was that? According to Wikipedia, the term war on drugs was popularized at a press conference in 1971 where Richard Nixon declared drug abuse public enemy number 1.
Okay.
So we're about 9 years into the war on drugs.
Yeah. And we know that that kind of continued through the 80s in the Reagan administration and the Say No to Drugs. And I have visions of those public service commercials with the egg frying in the pan. This is your brain. This is your brain on drugs.
I know those. I know exactly what you're talking about.
Okay. So evidence gets turned over to the police. The police ask TLO's mom to bring TLO down to the station, which TLO's mom did, and where TLO admitted to selling drugs. And so on the basis of that confession and the evidence found by Choplik, the state brought these delinquency charges against TLO. And then we have a case.
And then we've got a lot of, well, it's one case, but
it's got a lot.
This case goes through a few more steps than our usual cases.
And, and I just want to say, like, it goes through a few more steps largely because this is one of those foundational cases, right? Like the courts have really not significantly wrestled with this stuff yet.
Or at least the Supreme Court hadn't.
Right.
A lot of lower courts had dealt with this question of like what standard applies to school officials who search students.
Right.
But this is the first time that this issue gets to the Supreme Court, and the Supreme Court hadn't spoken on this issue yet.
And so it had to weigh all of this stuff that had been percolating in the lower courts, right?
Right.
Yeah.
And so the kind of the context here is we've got these delinquency proceedings going on against TLO by the state of New Jersey. So this is it might be helpful to kind of think of it as a criminal case, essentially, where New Jersey is saying, hey, TLO is a delinquent. She broke the law. She's underage. So, special consideration goes into that. But as part of that, TLO is basically arguing that the evidence that the state is using to basically make the case that she's a delinquent, all of that was obtained unconstitutionally. And if it hadn't been for the unconstitutionally obtained evidence, she never would have confessed. And so therefore, the confession itself also needs to get tossed out, because it is fruit of the poison tree,
I'm with you. So they're basically saying all of this stuff should get tossed out because it was not legally obtained.
Exactly. And so if you watch most cop shows, they don't do a great job of dealing with the Fourth Amendment. But like Law and Order, like, they talk about warrants, probable cause, all of that stuff all the time. And so this is kind of the criminal procedure stuff that we've got to be concerned about. And so that's kind of where we're at. So unlike a lot of our cases, this is a criminal case, not a civil lawsuit.
Right.
So TLO's arguing that all this evidence needs to get thrown out. The juvenile court hears her motion and essentially denies the motion to suppress and says, you know what, this evidence was obtained fine. No real concerns here about the assistant principal's actions. School officials can engage in searches as long as those searches are reasonable. And here he had reasonable suspicion that a violation of the school rules had happened and that the search was necessary to maintain school discipline and enforce school policies. So we're not going to upset this apple cart. We're going to let the evidence into evidence.
And those of you who know about searches in schools are probably listening to that and thinking that sounds very familiar.
It does. And we're going to hear like 4 or 5 different versions of the reasonable suspicion standard. And everyone has kind of a slightly different flavor to it. This one, I think, is actually a little bit more deferential to school officials than what the Supreme Court ends up articulating. But it's all based on kind of the same
thing.
Logic, right? Like schools are different. They need to have a lower expectation of justification for searches.
Different from police, right?
Right. And that's going to be our point of comparison as we kind of talk through what standards school officials ought to have when they're engaging in searches of students.
Yes, exactly.
So the juvenile court denies the motion to suppress and ends up adjudicating TLO delinquent in March of 1981, and she gets sentenced to a year's probation.
Okay.
So don't do it again, some sort of supervision, that sort of stuff. She appeals that to the state appellate court and kind of makes the argument again that it was an unconstitutional search, should have gotten rid of all of this evidence. And the appellate court agrees with the juvenile court on the Fourth Amendment issue, but ends up reversing the delinquency adjudication or the judgment determining her to be delinquent based on this question of whether or not TLO had knowingly and voluntarily waived her Fifth Amendment rights to be free from self-incrimination before confessing. So the appellate court was like, hey, this isn't a Fourth Amendment issue. This is a Fifth Amendment issue.
Really?
Yeah.
Now, just to backtrack, because I don't think we mentioned it, the Fourth Amendment issue at hand is the unreasonable searches and seizures.
Correct.
Right.
Yeah. Yeah. Because this entire case hinges on whether or not the search was a violation of the Fourth Amendment, and the Fourth Amendment
protects against unreasonable searches and seizures, right?
Right.
Yeah.
Yeah. So the Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause.
Okay.
And so, everyone's kind of trying to figure out what that word unreasonable means.
Right. Okay. So basically what happened here is they decided that it wasn't a Fourth Amendment violation, but it was a Fifth Amendment violation,
right,
in that she was not read her rights, basically.
I don't know if she wasn't read her rights, like you have the right to remain silent. Anything you say or do will be used against you.
Miranda.
Right. If she was Mirandized or not.
Yes.
Also, I don't remember when Miranda was decided. But, the Fifth Amendment protects against kind of your right to be free from self-incrimination. So if you've ever seen somebody on the stand say, I plead the Fifth.
Yes, that's it.
That's what they're talking about here. But, ultimately, that's not really that important to this case because the New Jersey Supreme Court ends up taking the case because New Jersey, the state who's prosecuting the delinquency charge, didn't like that decision. And so they appeal it to the New Jersey Supreme Court, who ends up reversing the appellate court on both grounds, basically doesn't address the Fifth Amendment thing, and then says that this Fourth Amendment search, the search actually does violate the Constitution.
Interesting.
Yeah. And so the New Jersey Supreme Court orders the suppression of the evidence found in TLO's purse, which at that point basically means that the state has no evidence to find TLO delinquent because they don't have the marijuana, they don't have the rolling papers, they don't have the list of students, they don't have anything.
Yeah.
And they also don't have the confession because that came about because of
that evidence. Now, the only thing that could potentially stay in place is the school's discipline for being caught smoking.
Right. And yeah, so the New Jersey Supreme Court, they find that this is an unconstitutional search. They say that, yeah, school officials don't need a warrant like law enforcement does. So school officials just have to have reasonable grounds to believe that a student possesses evidence of illegal activity or activity that would interfere with school discipline and order. So again, a pretty similar reasonableness standard as what the juvenile court delivered.
So then why did they say that they didn't meet that standard?
Because the New Jersey Supreme Court didn't think the search was reasonable.
Really?
Yeah. So the majority opinion at the New Jersey Supreme Court says that possession of cigarettes isn't against school rules. You already had this teacher come in and say, hey, I caught these girls smoking. And so therefore, like,
the rule that was violated had already, like, it had been established.
Right. And so if you're searching for cigarettes, like, the possession of the cigarettes itself is not against the rules.
Right.
And so they say that basically there's not enough of a connection here between the rule you're trying to enforce and what you're trying to do with your search.
Oh, interesting.
And so they also say that, like, yeah, maybe she lied about whether or not she was smoking, like, hey, I don't smoke, or I wasn't smoking in the girls' room. But, you know, doing the search just to kind of prove her wrong or prove that she was lying, like, that's such a minimal thing that, like, it doesn't really justify going through her purse, which purses are so incredibly private.
Yeah.
Right?
Exactly.
Like, and so the New Jersey Supreme Court basically said, like, you know what? Sure, reasonableness is the standard, but this search wasn't reasonable.
Interesting.
Mm-hmm. And the other thing so there's really kind of two issues that all of these courts are fighting about. One is, what's the standard that ought to apply for searches of students by school officials? And the other one is this question about whether or not the exclusionary rule applies at all to evidence that is seized unlawfully by school officials that's used in criminal proceedings, and whether or not, like, exclusionary rule applies at all in these juvenile proceedings themselves.
Okay.
And so, you know, we talked about a little bit the exclusionary rule, but that basically just means that, like, if something is obtained illegally, you exclude it from evidence. You can't use it to prove your case if you're the state. And so there's this question about whether or not we ought to keep that rule for juvenile proceedings at all. And the importance of that is the question that New Jersey appeals to the Supreme Court. So New Jersey wants the Supreme Court to weigh in on whether or not the exclusionary rule applies to searches made by public school officials and teachers in school. That's the question that they want the court to grant cert on.
Okay.
And that's a really interesting point, because they're not asking the Supreme Court to say, what's the standard for Fourth Amendment searches by school officials? They just want to know this very narrow thing, like, does the exclusionary rule apply in this situation?
Okay.
And the Supreme Court hears that argument, and then, in something that I think is really unique, the Supreme Court comes back and says, hey, you know what? We actually want you guys to brief the question of whether or not the assistant principal violated the Fourth Amendment in opening respondent's purse in the facts and circumstances of this case. We don't want to address the exclusionary rule question. We want to address the substantive rights question. And that means that this case kind of got heard twice before the Supreme Court. And when the court did that, when they basically came back to the parties and said, hey, we want you to address a different question, Justice Stevens, one of the Supreme Court justices at the time, who ends up ultimately dissenting in the case, he kind of makes the argument like, what are we doing here? Why are we taking this case on kind of the merits of the Fourth Amendment when we initially granted it to look at the exclusionary rule? And it's kind of in this larger context of the war on drugs, where the Supreme Court had been doing a lot in this area to kind of roll back Fourth Amendment protections. And Stevens was kind of pointing out, like, this just seems like another evidence of, and he actually uses the phrase, judicial activism to continue to curtail Fourth Amendment rights.
Interesting.
Yeah. So, like, even the court addressing this question is itself a little controversial.
Wow.
So it gets to the Supreme Court. The Supreme Court addresses the question, what standard applies to searches done by school officials on school grounds when they're searching students?
Okay.
That's the question the court decides to answer. They actually don't address the exclusionary issue at all, because they say essentially, like, in order for something to be excluded, it has to be an unconstitutional search. And here we don't have an unconstitutional search, so we don't have to go to whether or not the evidence ought to be excluded. So, spoiler alert, Supreme Court says that this was a constitutional search. And they get to that conclusion by a 6-3 majority. So the majority opinion is written by Justice White, and he's writing for 6 justices, and he answers 3 questions, essentially. And every one of these questions is really important, and oddly enough, the first one has universal agreement. All 9 justices agree with the answer to the first question. It's the second 2 questions where there's some disagreement.
Okay.
So the first question that they ask is, does the Fourth Amendment apply to searches conducted by school officials? Very baseline question, like, does this Fourth Amendment prohibition on unreasonable searches and seizures even apply to teachers?
Yes.
Hey, Jamie, you got it. Yes, it does.
Absolutely.
You would think that would be very, very simple, right?
I mean, I wouldn't because I know where this is going. But, there's 2 phrases in the Fourth Amendment, right?
Mm-hmm.
And one of them has the word reasonable in it, and the other one is probable cause.
Right.
So I know that's what they end up wrestling with, right?
So the state basically makes 2 arguments, Jamie, to your point. Like, one of those arguments that the state of New Jersey is making is that the Fourth Amendment only is meant to address searches carried out by law enforcement.
Right.
So it only applies in situations where we're trying to enforce criminal law.
Okay.
And the Supreme Court says, yeah, that's not right. We've interpreted the Fourth Amendment to protect privacy and security against all sorts of arbitrary invasion by governmental officials. It would be, they say, anomalous to say that individuals have privacy rights, but only when they're suspected of criminal behavior.
Right.
And so the Supreme Court kind of basically says, like, yeah, we don't buy that. The Fourth Amendment does much more than just articulate when police officers can search.
Yeah.
But the other argument they make, and this is the one that I think is really interesting and goes to kind of just a perennial issue in school law, is the state makes the argument, or the court addresses the argument, whether or not school officials are even exercising state authority such that they would be subject to the Fourth Amendment. Because we've talked about it in other episodes, there's this idea of in loco parentis.
Right.
Which is Latin for in place of the parents. It's this legal doctrine that comes all the way from the 1700s in England, all the way through American common law, that basically says that school officials or teachers or tutors, whoever it might be, exercise delegated parental authority when they're engaging in teaching. And so that idea has been really influential. It came up when we talked about the Brandy Levy case. And the court kind of looks at this and says, you know what? That doesn't make sense anymore in our contemporary society. We can't say that these teachers are exercising parental authority and are, immune from the Fourth Amendment because these are massive public schools. We've got compulsory attendance laws. We've found them to be state actors in a lot of other situations where, whether that's the First Amendment or the 14th Amendment's due process clause, it would be kind of anomalous, again, if we found them to be exercising parental authority in the Fourth Amendment context.
Okay.
Which, I think is really interesting just because it goes to this issue of where do schools derive their authority?
Right.
And if they derive their authority from parental authority, that kind of has really important implications. But if they derive it from state authority, that also gives them
2 very different authorities, right?
Right. With very different kind of like justifications, right?
Sure.
That's just something that I think is really fascinating, that I've argued against the continued use of in loco parentis. And this is one of, I think, the instances where the court kind of says, in loco parentis doesn't really make a lot of sense given contemporary compulsory education.
Yes.
So court says, yes, the Fourth Amendment does apply to school officials, but that's only the first question. We also need to ask what standard applies to school officials when they're engaging in searches. And this is where most of the disagreement comes between the justices. This is where the big fight happens.
Yes.
Because we've got different ends of this spectrum, right? So Jamie, you've pointed out, the Fourth Amendment says you're protected against unreasonable searches and seizures. And then it's got that second phrase, which is no warrant shall issue except upon probable cause.
Right.
So what standard do we apply? For the police, they have to have, unless an exception applies, you have to have a warrant based on probable cause. And that warrant has to be issued by a court. The court has to say, yes, you've got probable cause, go search.
Right.
And the argument here is that like schools, they're not quite law enforcement. It might not make sense to make a principal go to a court every time they want to search a kid's bag. So what standards should apply?
Right.
So we've got all the way from schools should also be subject to the probable cause standard, all the way down to students don't have any expectation of privacy in schools, so schools can search whenever they want.
Right.
And so we've got to kind of figure out where within that spectrum we ought to be.
Okay.
And then the state of New Jersey makes a really interesting argument. The state of New Jersey argues that students don't have any reasonable expectation of privacy in the stuff they bring to school.
Oh, boy.
Oh, boy.
That's bold, New Jersey.
Right. So, yeah, talking about that spectrum,
yeah,
they're on the other, they're on the far end.
They're on one side. Yep.
And their argument is essentially that because students are under such extreme, pervasive supervision, that they don't really have an expectation of privacy in anything that they bring to school, because everything they do in school is scrutinized. It's subject to all of the oversight that goes on in schools.
It's an interesting argument.
It is, and it doesn't get very far. So the court says, no, thank you, New Jersey.
Nice try.
Right. They say that privacy and a sound educational environment, those things can coexist. Like students can have privacy and you can still maintain order and discipline.
Right.
And then they say this line, there were other cases where it was decided that prisoners in jails and prisons don't have any expectations of privacy in their cells. And that's kind of what New Jersey was arguing, because of the substantial oversight and all that stuff. So they're trying to draw parallels.
Yeah.
And the court has this beautiful line. The court says, "We are not yet ready to hold that the schools and the prisons need be equated for the purposes of the Fourth Amendment."
Let's start comparing schools and jails.
Right. Which isn't a comparison. We don't want our schools to be these authoritarian places of limited freedom and
no.
panopticon and all of that. Right. But I also like that phrasing of "we're not yet ready,"
implying, one
someday
day
we might be.
Let's come back. We'll have the conversation a little later.
Right. Or it could be tongue in cheek, this is so ridiculous that
we're not ready. We're never going to be ready.
Exactly.
Right.
Let's hope it's tongue in cheek, because the alternative is sad.
Mm-hmm.
So the court kind of comes back and says they do have expectations of privacy. What we have to do is we have to balance those privacy interests against the state's interest in maintaining a sound educational environment.
Right.
And so when the court balances those interests, it essentially says, based on this balance, we don't need the intense warrant and probable cause requirement, because schools are different from law enforcement. They've got different purposes. They're different environments. Schools are supposed to be educative. They're supposed to be teaching children. Yeah. There's much more informal relationships. They're not enforcing punitive rules.
Right.
All of these different justifications that would say the warrant requirement is just unsuitable to the school environment.
Right.
And so instead of the warrant and probable cause requirement, the court articulates kind of a middle ground. And this is the standard that is applied in all subsequent cases for student searches.
Yes, and it has not changed to this day.
It has not. And the court has only addressed this standard a couple of times since then, the Supreme Court at least.
Yeah.
And in Safford versus Redding, which is another case that we'll probably talk about, which was a strip search case from the early 2000s, they apply the TLO standard to find that strip search was unconstitutional.
Right.
But they do apply the TLO standard, right?
Yes, exactly.
Yeah. So here it is in all of its, I wanted to say verbose glory, but it's not that long. So the legality of a search of a student should depend simply on the reasonableness under all the circumstances of the search. Determining the reasonableness of any search involves a twofold inquiry. First, one must consider whether the action was justified at its inception. Second, one must determine whether the search as actually conducted was reasonably related in scope to the circumstances which justified the search.
Yeah.
And there you have it.
That's it.
Justified at its inception, reasonably related in scope.
So basically what we're talking about is, did you have reasonable suspicion to conduct the search in the first place?
Mm-hmm.
And did you ensure that what you searched was reasonably related to the suspicions that you had? and did not go too far, right?
Right. Yeah.
So, and that's basically it. So, I mean, let's try to think of sort of a hypothetical example, because I think the scope thing is interesting, right? Like you could be justified. Let's say it's smoking in the bathroom, because that's the case we're talking about today. Let's say you walk by and you smell smoke in the bathroom. The court basically says, yeah, that's going to give you reasonable enough suspicion to search a student, right? To see if, let's say, they were carrying cigarettes or a lighter or something like that, right? But if, like, let's say, for example, you opened up TLO's purse and found absolutely nothing. Does that give you the right to go and search TLO's car, right?
Right.
Now, I would say...
Answer would be a big old no.
Right. I would say no, because if you walk by and you smell smoke, right, then obviously whatever you think is happening kind of in the moment there, right? And so it's reasonable to assume that they might have some kind of smoking paraphernalia, a lighter, cigarettes, whatever, on their person.
Right.
But what they are suspected of doing, like, what are you going to find in their car that had any sort of bearing on, in that moment, walking by the bathroom and smelling smoke?
Right.
So that's the scope piece. You could search their purse, but you can't search their car.
Right. And there's also this question of intrusiveness. So there's the justification issue, and then there's the scope issue. The justification, we have to have kind of reasonable, articulable suspicion that the search is going to turn up evidence of wrongdoing, right?
Like a rule being broken. Yeah.
A rule being broken, a law, whatever it might be.
Yeah.
And that has to be more than a hunch. It's got to be based on something, right?
Yes. Listen, it could be as simple as like a student saying, hey, I heard that so-and-so was smoking in the bathroom. It could be as simple as that.
Right. Unless you have a reason not to believe that student.
Exactly. Right. But I'm just saying, like, it could be as simple as that. Right. You don't have to have physical evidence of something happening. You don't have to have video evidence, for example, of something happening. Like, it can be as simple as that.
Right. And yeah, so within our reasonableness standard, we've got a reasonableness standard.
Yeah, exactly.
But the circumstances that justify the search are going to inform the scope of the search and what's allowed for the scope, because the scope has to be reasonably related to the objectives of the search.
Right.
So Jamie, to your point, like, if they're smoking in the bathroom, if that's your justification, then your scope has to be limited to the things that would advance that justification, right? Like that would advance the purpose of finding evidence that they were smoking in the bathroom,
right?
Which is kind of the issue that, when you're dealing with cell phone searches comes up a lot. Like, are you looking on the cell phone for evidence of the particular wrongdoing that you suspect? Because possessing the cell phone could be against the rules, but that doesn't give you a justification to search it.
Yes, exactly.
Right?
Exactly.
And then the other piece of this scope issue is whether or not the search is excessively intrusive in light of the age and sex of the student and the nature of the infraction.
Exactly.
And I think both of those are really interesting, right?
Hugely important.
Because of the power imbalances between teachers and students, because of the age differences, the sensitive ages that these students are, like all of those things come into play. And then also the nature of the infraction.
Yes.
So essentially, the more severe the
possible
violation or the threat of safety, security, whatever it might be, then the more intrusive the search can be.
Right.
So
and we're going to talk, like when we do the Safford case, for example, like that's a big thing.
The quintessential scope case,
right?
Right?
Exactly. So we'll get into a lot more detail on that when we talk about the Safford case. But yeah, so it's basically like smoking in the bathroom versus evidence of, dealing heroin, for example, right? Like,
oh, you went there.
I didn't go there. I'm using it as a hypothetical example.
Right. Right.
No, but like,
so, don't strip search a student for over-the-counter pain meds.
Right. That's
which is the TLO or the Safford.
That's a little foreshadowing.
Yeah.
But yeah, like the nature of the potential infraction, especially when it comes to things like safety, jeopardizing the safety of others or self or whatever. If safety comes into play, then yeah, schools are often provided a lot more deference, right?
Right.
When it comes to how intrusive that search can be.
Yeah. So we've got to have articulable suspicion that would indicate that our search is going to turn up evidence. And the search itself has to be reasonably related in scope, given the circumstances, age, maturity of the child, and what it is we are actually trying to look for and enforce. Yep. And that's the standard the Supreme Court lays down. It strikes this nice kind of middle road balance, right, between the school's interests and the student's interests. The dissents in the TLO case kind of say, this standard is really a little bit too deferential to teachers and school officials because the justified at its inception bar is a really low bar to meet because you just have to have kind of these reasonable, articulable suspicions that the search is going to turn up evidence of wrongdoing. And then the scope thing, you talk about the nature of the infraction, but this justifies searches to enforce even the most minor infraction. And that is something that the dissents are really worried about. So the dissents here would have applied a stricter standard, not necessarily the warrant requirement, but still would have used either a version of the probable cause standard, which would be a little bit higher than the reasonableness standard that we've got. But I think all told, the Supreme Court here kind of strikes a decent balance between the rights of students, even though, it could be said that it is a pretty deferential standard.
Yeah, I agree. I mean, I'm also coming at this from a principals kind of background. And I'm not saying that because I was a principal, I just liked searching students.
Right.
But again, I have a responsibility or had a responsibility to maintain the efficient and effective operation of the school. And, it's harder to do that the more your hands are tied.
Right.
Right. But like you said, you think the Supreme Court struck a pretty good balance here. And I think that the fact that we're pushing 40 years on this case, and this remains the sort of gold standard, for lack of a better phrase, with respect to searches, I think is good evidence that they did seem to strike a pretty decent balance here.
Yeah.
Right?
Yeah, that's fair.
Some cases, as with everything, additional cases come along and further refine where those goalposts are.
Right.
Like Safford and other, and other cases.
Well, that's why I think they decided the Safford case, and we can talk about this when the distant future we do the Safford case. But I think Safford was a course correction because people had interpreted TLO to be too deferential.
Yeah. And so just we keep talking about the Safford case, and we'll go into more detail, but I think it's important to basically just say the gist of that case was you have a young female student who was suspected of passing out or selling or something over-the-counter pain meds like Tylenol or Advil or something like that, and the student was strip searched.
Taken to the nurse's office by a female nurse and stripped down to their undergarments and then asked to basically shake the elastic bands of their undergarments.
Yeah, exactly.
And the Supreme Court ends up saying,
you went a little too far.
Yeah, that was way too intrusive.
So that's a big overview. You'll still want to listen to that episode when it comes out because it's interesting. But that's what that case was about. And I would agree with your assessment of that being a kind of course correction of saying, okay, TLO still applies, but whoa.
Right.
Take it down a notch, people.
TLO is not a golden ticket.
No, exactly.
And so taking it back to the facts of TLO. So I think TLO itself is a good example of how the standard of TLO applies, right? So the last question that the court kind of deals with is, was the search of TLO reasonable? And unlike the New Jersey Supreme Court, the United States Supreme Court says, yeah, this seems pretty reasonable.
Yeah.
They were caught smoking in the restroom, and smoking requires cigarettes. So having cigarettes would suggest that a person was smoking.
Right.
And so therefore, if you found, or if you're looking for cigarettes, that would help you make the case that TLO was smoking in the girls' room. And, that kind of contradicts what the New Jersey Supreme Court was trying to say.
Right.
Where that's not really going to be evidence of what you're looking for. And the Supreme Court kind of says
yeah, it is.
Yeah, it's going to help us decide this. We're not trying to establish the fact of smoking in the girls' room. We're trying to find something that would make it more likely or less likely that she was smoking in the girls' room.
Right.
And, they've got this line that it is universally recognize that evidence, to be relevant to an inquiry, need not conclusively prove the ultimate fact and issue, but only have any tendency to make the existence of the fact more or less probable.
Okay, now please repeat that in English.
Does the thing you're looking for make it more or less likely that they did the thing you think they did? Ooh, that was pretty good.
Yeah, nice. On the fly, too. Good job.
Look at me.
Yeah.
Yeah. Law can be kind of incomprehensible sometimes, huh?
Well.
And so that's when the court says, yes, it's justified at its inception because evidence of cigarettes would indicate that they were smoking. And then it was reasonably related in scope because all you did when you were looking for the cigarettes was open the purse.
Mm-hmm.
And then when you opened the purse, you saw the rolling papers, and that gave you a brand new justification to do a deeper search because of this kind of like common sense conclusion about human behavior, where if a middle schooler has rolling papers, Jamie, I think you made this point, they're not rolling tobacco,
right?
Especially if they've already got cigarettes next to it.
Where there is smoke, there is fire, and where there are rolling papers, there is marijuana.
But,
generally,
yeah, we'll put that on a t-shirt. All right. So the ultimate conclusion, Supreme Court says no Fourth Amendment violation. This reasonableness standard applies. This search was reasonable.
Yep.
We don't see any reason to suppress this evidence or overturn her delinquency adjudication.
Right. There it is, folks. New Jersey versus TLO.
Mm-hmm.
Yeah. A big time foundational case. Yeah. Like we've said, has kind of set the standard for searches over the last 40 years.
Mm-hmm.
So here we are.
Yeah. And still good law, still plugging along.
Yep.
I think that there is definitely something to be said of TLO kind of tipping the scales in favor of school authority, especially as we've seen kind of subsequent cases that have really, in most cases, limited students' rights.
Right.
Because that's one of the things that the dissent really picks up on, or Stevens' dissent in this case really picks up on, is kind of the educative function of the law and what students learn in schools.
Mm-hmm.
And so Stevens was really worried about kind of the implicit messages that students get about their rights in schools if we let schools kind of willy-nilly search them with very kind of minimal justification.
Well, and listen, and that is a very reasonable, to use that word again, like that, that's not an unreasonable concern. Okay.
Right.
And, just think about the fact that, the message that it sends when you walk up to a school and all you see are metal detectors, right?
Right.
And every time you walk into a building, you have to pass through a metal detector, right? Like, what does that say about people's expectations of privacy?
Mm-hmm.
So,
right. Yeah.
Yeah.
It's kind of what's the hidden curriculum of the school, right? Like, so what lessons are they teaching that they don't maybe explicitly teach?
Right.
And Stevens was very worried that we're teaching students to kind of discount these important constitutional protections. And by teaching them to discount them in schools, then they're not going to take them as seriously as adults.
Right. Totally. And hidden curriculum. Like, I was talking to a teacher a few weeks ago, and she was telling me about the metal detectors that are in her school and how at the very top, there's a button that has 3 positions, and it says school, airport, jail. Like, those are the different sensitivity settings on the metal detector.
Yeah.
And I'm like, well, wow, what does that say? Right. And
yeah, well, at least they're in that order, I guess.
Well, I don't know. I don't know if that's the order.
Right.
Anyway, I don't know.
That's really interesting.
There's a lot we could say about metal detectors and those kinds of searches, but that's, but again, there have been a lot of cases that have dealt with those kinds of, either random searches, drug sniffing dogs, metal detectors, drug tests, urinalysis,
suspicionless searches.
Right. There have been a lot of cases, and
we'll talk about that one someday too, with the Earls case and
right,
and the Vernonia case.
Yeah. So there's a lot to talk about, folks.
We're not going to run out of cases.
No, we are not. All right. Well, that's good for today. What's our homework, sir?
Your homework is to clean out your purse.
Leave your drugs at home.
Find Chalk and Gavel wherever you get your podcasts. Like, rate, review. That's a huge help for us as we continue to grow our reach. You can find us on social media at Chalk and Gavel or on our website, chalkandgavel.com. We'd love to continue the conversation, hear your feedback. If you've got ideas for cases or bell ringers, please let us know. That is a wonderful way for us to not only kind of see what you all are thinking about, but just to stay connected to what's going on that is of interest to you.
That sounds good. All right, folks. Well, we'll see you in 2 weeks. We'll talk another school law case, and that does it for us. I'm Jamie Cutler. Wait. Yep.
I was going to say, I don't know. I think we should pivot to true crime.
We'd probably end up with more listeners.
Hey, we did a criminal case. This is a criminal case, right?
Okay.
So I think we are a true crime podcast.
We're venturing into the true crime. I'm going to relabel the show. All right. We'll see you in a couple of weeks. I'm Jamie Cudlitz.
I'm Chris Thomas.
Have a good one, everybody.